I have questions on each bucket. So on standing, if a new administration comes in and says, we're not going to enforce the environmental laws, we're not going to enforce the labor laws, your position, I believe, is no state and no individual and no business would have standing to challenge a decision due as a blanket matter, just not enforce those laws. Is that correct?
That's correct under this court's precedent, but the framers intended political checks in that circumstance. You know, if an administration did something that extreme and said we're just not going to enforce the law at all, then the president would be held to account by the voters, and Congress has tools at its disposal as well.
And what are those tools? Because you mentioned earlier this would be extraordinary, but I think Congress in 1996 and today, but in 1996, which is the relevant date, thought the immigration problem in the United States was extraordinary. And the lack of enforcement to the degree that Congress, as of 1996, wanted. And so that's why they toughened the laws and constrained the executive's discretion. At least that would be, I think, the position. So if courts aren't going to be able to enforce those congressional mandates, what are the exact tools that Congress has to make sure that the laws are enforced in the United States?
Well, I think that Congress obviously has the power of the purse. It can make the executive's life difficult with respect to its decisions about how to appropriate funds. Congress has oversight powers. These were the same kinds of considerations that the court cited in Raines versus Byrd when it was confronted with some of these same separation of powers, structural, constitutional considerations, and identified the fact that Congress wasn't powerless to act. But Justice Kavanaugh, if I could just for a minute press on the premise of your question that Congress in 1996 intended these to be judicially enforceable mandates. I guess I would say two things. One is that Congress has never actually appropriated funds to DHS to permit treating all of these shalls as mandatory judicially enforceable shalls. And the other thing is that Congress specifically precluded judicial review in provisions like 1226E and 1231H, which we haven't had a chance to discuss. And I think that demonstrates.
Those are good arguments, except we have precedent that's against you on those. So at least on 1226, and I know you have a response to that, but don't need to go into it now. But I think your position is instead of judicial review, Congress has to resort to shutting down the government or impeachment or dramatic steps if some administration comes in and says we're not going to enforce laws, or at least not going to enforce the laws to the degree that Congress by law has said the laws should be enforced. And that's forcing, I mean, I understand your position, but it's forcing Congress to take dramatic steps, I think.
Well, I think that if those dramatic steps would be warranted, it would be in the face of a dramatic abdication of statutory responsibility by the executive. And there's a reason we don't see that throughout our history, because of those political checks that prevent the executive from taking those kinds of actions. And, you know, it'd be like saying if the president decided to pardon every federal criminal and release them all, obviously no one could sue about that, but there's a reason that doesn't happen.
Right, but there's also, just to press on this a little more, you make a big point in your brief, this is unusual, this is rare, but it's unusual for Congress to mandate particular exercises of enforcement or prosecutorial discretion. Most statutes do not say the executive shall detain, shall prosecute, and I think that's why this is an unusual situation, but I take your point on that. Can I move to remedy then, because I have some problems with that, as you might imagine. Set aside, you said the judges on the D.C. Circuit haven't paid attention to text, context, and history. I guess I would respectfully push back pretty strongly on that. I sat with judges like Silberman and Garland and Tatel and Edwards and Williams. They paid a lot of attention to that. And the government never has made this argument in all the years of the APA. At least not that I remember, sitting there for 12 years. I haven't seen it made. It's a pretty radical rewrite, as the Chief Justice says, of what's been standard administrative law practice. And you devote 3 pages in your brief to this complete change that all these judges have been doing for all these years, and the government comes up and acknowledges that in case after case after case with the labor or energy, environmental. And I think it's a big step. And you say they're not paying attention to the text. Yeah, we did. Set aside means set aside. Then that's always been understood to mean the rule's no longer in place. No one's really had no case has ever said what you're saying, anywhere. No one, it's a recent law review proposal, good for that, but that's not been the law. And so I find it pretty astonishing that you come up here and I realize it's not the main part of your submission, but I'm just going to push back pretty strongly on the, 3 pages for just toss out decades of this court's law, of circuit law, and you've got Public Citizen and Texas coming after you on this. They don't usually unite in a administrative law case, in my experience, and they both say your position is completely unprecedented on that. So that's not really a question, but that is a comment on what I think is a pretty extreme argument. And I know it's not your whole argument, but this piece of the argument, so I don't want to overstate what I'm saying here. Just this piece of your argument, I think, is pretty extreme. So
Justice Kavanaugh, let me say first, let me clarify that of course I didn't mean that the DC Circuit isn't generally paying attention to text, context, and history, and I should have been more precise that I don't think that the court has ever had the opportunity to actually engage with the arguments that we're making here in this case. And what I was trying to point out is that I don't think it's too late for courts to start to engage with these arguments, and I recognize that we ourselves are landing on them somewhat late in the day, but we have been making these arguments consistently. I think the first time we started to make them was in 2008 in the Summers versus Earth Island Institute case. We've repeated it pretty consistently since the Little Sisters case in the last administration and in cases here. And some lower courts, now that they are actually looking at our arguments, have recognized the force of those arguments. It's not accurate to say that no court ever has considered this or accepted it. The Fourth Circuit has said that universal vacatur is not a permissible remedy under the APA. Chief Judge Sutton in the Arizona versus Biden case in his separate concurrence recognized the force of our arguments about vacatur under Section 706.
And what does it mean just in this case? Does it mean, for example, if we rule against you on the other issues, but then agree with you on the remedy, the set-aside point, does that mean the government can then ignore the substance of this court's ruling in other states?
No, not at all. I think if this court then
Why
determined
not?
to issue, well, this court would have authority, of course, to issue a declaratory judgment, and we would abide by that throughout the nation if this court said what the law meant in this area. So I don't think it suggests that courts are going to be powerless to issue remedies here. They'll just be confined to the traditional legal remedies that pre-existed the APA as Congress intended, and that can include in other contexts injunctions, injunctive relief. It can include declaratory judgments and any other permissible remedy that pre-existed the APA.
Thank you.